Good afternoon, everybody. My name is Sean Bernabeu from Disparate. I am a business performance advisor in the New York region, and welcome to our webinar today. Today we have a webinar about discrimination and reasonable accommodations in the COVID era and how it all relates to the American with Disabilities Act. Disparate had worked on this presentation along with the law firm of BakerHostetler. Today we have Amy Traub from BakerHostetler joining us. She is the chair of the Labor and Employment Group at BakerHostetler. And also George Patrick. George Patrick comes from the Houston area, and he is part of the Disparate Human Resources team. I will hand it off to Amy and George and allow them to begin their presentation on the topic. And just a couple of housekeeping items before we begin. If you have any questions, you could put them in the Q&A box and we will address them at the end, time permitting. Any questions that are not addressed, we will follow up with you individually. And there will also be contact information at the end of the presentation if anybody wanted to reach out and ask questions directly. So Amy and George, handing it off to you and look forward to the next hour.
All right, well, thank you so much, Sean. Good afternoon, everyone. I'm George Patrick, Human Resource Specialist with Disparate. Let's go ahead and jump into the material that we have here today. The COVID-19 pandemic, it really has affected all industries and workplaces across this country and basically across the world. And while we navigate through these ever-changing guidelines along with understanding and applying new and existing laws, we must remember employees are still protected against discrimination and other work-related misconduct. That is why this topic is so important. Covered employers, such as yourselves, under the Americans with Disabilities Act, should be familiar with the provisions and the rights under the ADA. This will better equip you to address employee needs, identify liabilities, and minimize your exposure to risk. Amy, what do you have to say about that?
Yeah, that's right, George. Couldn't agree more. In addition to the employer who's making hiring decisions, the workforce just won't look the same as before COVID-19. So we're going to be talking today about some of the choices that employers are now facing that are quite unique. At each stage, there's really potential discrimination from an impact and a treatment standpoint. Not only do employers need to be familiar with the Americans with Disabilities Act, which, as Sean said, we'll spend some time with today, and generally with disability accommodations, but there are a number of other federal, state, and local laws that require employers to provide reasonable accommodations for other protected characteristics.
All right, so as we get started today, we'll be addressing workplace discrimination and reasonable accommodation related to COVID-19. So we'll be discussing several topics, including what is the ADA, ADA interactive process, reasonable accommodations, ADA coverage in COVID-19, accommodations unrelated to disability, pandemic-related discrimination, stigmas, disparate treatment and disparate impact, the differences, and of course, employer do's and don'ts, key considerations to take away. So Amy, what is the ADA?
Well, certainly the pandemic has led to an increased number of requests for accommodations from employees. The Americans with Disabilities Act, or the ADA, is the primary federal law under which these requests may arise. It's not the only law. We'll touch on some others shortly, but it is the federal law at issue. It was enacted in 1990 to protect individuals with disabilities. It applies to all aspects of employment, as you might imagine, from hiring to firing to promotions, job training, compensation, and then other terms and conditions of employment. The Equal Employment Opportunity Commission, or the EEOC, enforces workplace anti-discrimination laws, and the ADA is one of those laws that the EEOC enforces. It provides protection in a number of areas, but today, as you said, George, we're really going to spend our time on two primary topics. One is accommodations in the workplace as they relate to COVID-19 related issues. And that can be under the ADA and a number of other statutes. But then we'll separately talk towards the end of the presentation about rebuilding your workforce and how some of these issues can come into play under this law and some others as well. So let's start with some of the basics about the ADA. What does qualified individual mean? So the folks that are protected by this law are qualified individuals with disabilities. An individual is a qualified individual if, with or without reasonable accommodation, they can perform the essential functions of the position that they hold or the position that they desire. That takes into account a number of factors like skill, experience, education, physical, medical, safety, and other requirements that an individual has to meet within a job. An individual is not qualified if they pose a direct threat, and that's where you see a lot of the attention being given in the COVID-19 area. That means that the individual is a significant risk to the health or safety of themselves or to others, which risk cannot be eliminated by some reasonable accommodation. So once it's determined, George, that an employee is a qualified individual, the next step in the analysis is really to determine whether the person is disabled. The definition of disability is a physical or mental impairment that substantially limits one or more of the major life activities of the individual. So generally speaking, the person has to have a record of or be regarded as having a substantial, meaning not minor, impairment. And a substantial impairment is one that significantly limits or restricts a major life activity, those being things like hearing and seeing and speaking and breathing, performing manual tasks, walking, talking, caring for oneself, learning, and working. So it includes ones that you might automatically assume: blindness, hearing impairments, some mobility impairments, cancer, cerebral palsy, epilepsy, multiple sclerosis, and other types of psychological disorders as well. Things like post-traumatic stress disorder, obsessive compulsive disorder, schizophrenia, bipolar disorder. So there's a wide range of definitions of disability under the ADA and of course under state and local law. The one that we keep hearing about in this COVID-19 area might be akin to something like an everyday stressor. It's important for employers to know that while everyday stressors are not typically covered by the ADA, they could actually form the basis of an ADA claim if a special set of circumstances arise. Something like, due to COVID-19, employee A has developed anxiety and needs an accommodation. You and I both know we're seeing that every day in our practices. In a situation like that, the best practice for the employer is to engage in what's known as the interactive process, which includes requesting appropriate medical documentation, ultimately with the goal being to determine whether a reasonable accommodation can be provided to that employee. And we touched on this in greater detail in the following slides.
Yes, so now that we have an understanding of who is protected, let's talk about what is the interactive process. One of the things we need to determine is what triggers the interactive process. Well, one thing is when an employee requests accommodation. That's a straightforward trigger for having an interactive process. The other thing would be when the employer becomes aware of a need for accommodation by observation or by third party. Observation could be that you're recognizing that they're taking more time off, maybe every Thursday. You can see there may be a need there. You find out that maybe the employee has a mother who has an illness. They have to go to the doctor every day or every Thursday, or by a third party. Maybe that's through some other means that you get awareness that this person may have a need. At that point is when you need to conduct a discussion or serious discussions with that employee. You want to collaborate with the employee to determine if the accommodation is even needed. Determine what accommodations will help the employee accomplish the essential functions of the job. And that was the most important thing, is the essential function of the job. And not to do a side note here, but you want to make sure that your job descriptions are well written so that it completely identifies these essential job functions. See, the interactive process is not always a single conversation. It can involve a series of conversations where ideas are shared. Don't make it too formal. Don't overcomplicate the discussion. It's a collaborative effort between you and your employee to determine what accommodation, if any, can help him or her to accomplish, again, the essential functions of the job. The discussions could be verbal. They could even be through written communications as well. So Amy, tell me, what are some of the legal considerations in working through the interactive process in this COVID-19 era?
Well, for starters, COVID-19 has not itself been deemed a disability for ADA purposes. Just like the seasonal flu and other conditions of a short duration are not considered a disability under the ADA, complications, though, arising from illness that are caused by COVID-19 might lead to the condition becoming an ADA-covered disability. So the EEOC has basically said on this point, as we continue in this ever-changing pandemic, employers and employees should be, quote, as flexible and creative as possible in order to reasonably accommodate employees' needs during the pandemic. So what that means is that after receiving an accommodation request, employers should engage in that interactive process to clarify what the individual with a disability needs and to identify an appropriate reasonable accommodation. Now, both the employer and the employee have to participate. They both have an obligation to participate in the interactive process in good faith. And although, as you said, George, it's an informal process, an employer's failure to engage fully and thoroughly in the interactive process could lead to liability, just like an employee's refusal to cooperate in the interactive process by providing the employer with necessary information to gauge the accommodation request could have their accommodation request denied for not providing the required information. So you had talked about a couple of instances of when a reasonable accommodation interactive process should be invoked. And one of the things you said was certainly if the employee comes forward and requests the accommodation. Well, you might also be on notice of an employee's disability if they make regular requests that seem, or statements that might seem like they have a potential disability. Maybe they are constantly asking for a mental health day, for example, versus a one-off, they've been under a lot of stress, oh, I need a mental health day. So it's kind of listening. If an employer is put on notice of an at-risk condition that triggers a concern about the employee's health being jeopardized upon returning to the workplace, the employer has to engage in this individualized assessment of whether that condition will pose a direct threat to the employee's own health as well. So we're seeing some of that with COVID-19, but be wary, employers, because the EEOC has made it very clear that employees who are suspected to have a disability or who are known to have a disability or regarded to have a disability cannot be precluded from coming into work on the basis that the employer is concerned about them contracting COVID-19 and or spreading it to other employees. It really needs to be a dialogue. It needs to be that interactive process. So after receiving an accommodation request, employers should ask questions. Get the medical documentation always to help decide if the person has a disability and if there is even an accommodation that would be reasonable, or would it cause an undue hardship? You could ask, how does the disability create a limitation? How is the requested accommodation going to effectively address the limitation? Is there another accommodation that could effectively address the limitation? And most importantly, will the requested accommodation enable the employee to continue performing the essential functions of their job? Essential functions meaning the fundamental job duties.
All right. Well, thanks, Amy. So you mentioned the term reasonable accommodation. So from an HR standpoint, a reasonable accommodation is any change or adjustment to a job or work environment that permits a qualified applicant or employee with a disability to participate in the job application process, to perform the essential functions of the job, or to enjoy benefits and privileges of employment equal to those enjoyed by employees without disabilities.
That's right, George. Reasonable accommodations can include modifications or adjustments to maybe a job application process that enable a qualified individual with a disability to be considered. Since the pandemic, a lot of employees have been working remotely. I'm remote, you're remote, Sean's remote. It's likely that moving forward, workers will request to continue working remotely. And they may request this as a disability accommodation. employers need to understand how to handle this. Perhaps allowing an employee to continue working from home during the pandemic was only a temporary thing that now that businesses are beginning to reopen really cannot be sustained longer term. This is where the question of what's reasonable in the first place comes in, or alternatively, whether a proposed accommodation might pose an undue hardship. Now, undue hardship, generally speaking, exists if the accommodation is too difficult, too expensive to provide in light of a number of factors: size of the employer, financial resources, needs of the business. Employers could consider claiming undue hardship if the reasonable accommodation is unduly disruptive to other employees' ability to perform their jobs every day, or the employee seeking leave, for example, as a reasonable accommodation is unable to provide a fixed return date, and the employer therefore can't plan or permanently fill a position. Before the pandemic, a lot of accommodations might not have posed a significant expense when considered against an employer's overall budget and resources, but the sudden loss of some, or in some circumstances all, of an employer's income stream because of the pandemic has really become a relevant consideration on the undue hardship question. Another consideration, George, is all of the governmental restrictions, as those continue to change, or they're partially or they're fully lifted. As those things happen, the need for accommodations also changes. So that might result in more requests for short-term accommodations or more granting of accommodations on a short-term basis. There have been some recent cases already brought to this effect. And one of the most important things that I can't stress enough is for the employer to look at the city, the county, the state, and the federal restrictions that are in place from the standpoint of business reopening: mask wearing, social distancing, OSHA guidelines. Employers who generally just don't want to come back to work, but their governmental restrictions have really opened up businesses to do business almost as per usual, or more so than they had been previously. Really, those accommodation requests begin to really change. So let's talk a bit further about this dovetail that we've been kind of dancing around between ADA and COVID. As I said before, COVID-19 is not in and of itself a disability. The effects of it on an underlying condition that may come from COVID-19 is what must be taken into consideration. So the EOC has confirmed in some recent guidance that employees can request reasonable accommodations if the CDC, the Centers for Disease Control and Prevention, deems them to be in one of these higher risk categories for severe illness from COVID. So employees in those categories can request an accommodation related to their underlying medical condition. So, I have lupus, for example, as a hypothetical. I'm an employee and I don't want to return to work, even though you've given me a return to work date. I would like to work from home. And my job, the essential functions of my job, can be performed from home. I'm going to request that accommodation because the CDC says that an autoimmune deficiency or disease or disorder like lupus, I'm at greater risk of not only contracting COVID, but potentially fatally contracting COVID. And so the employer has to engage in that interactive process. Now, importantly, the EEOC also clarified something that I think we saw trending, and that is an employer is not required to provide an accommodation for an employee solely because the employee's household member is at a high risk for COVID-19. And so that's important for employers to know, and that is something the EEOC has clarified. This by extension disability coverage just doesn't apply. And so in the case of my hypothetical, if my husband is the one who has lupus, my employer is not required to accommodate me simply because I have a husband at home who has a greater risk for contracting COVID. The other thing on this is that employees who simply refuse to return to work out of a generalized fear of contracting COVID-19 with no underlying medical condition or some other high-risk category could be deemed by the employer to have resigned.
Thanks, Amy. And in thinking about those type of accommodations that might be deemed reasonable for individuals who fit within these high-risk categories, all the following might be considered. So again, you want to look at maybe job restructuring. A leave of absence is considered a reasonable accommodation as well. Remote working, modified work policies, workplace policies, providing protective gear, installing barriers as well, changing workspace or equipment, or moving the location where the work is performed, doing that social distancing, modifying schedules to decrease contact with coworkers and or the public. Again, you got to think out of the box when you're looking at making accommodations, and again, make sure there's no undue hardship to your business.
So we've been talking about a lot of principles here, legal principles and HR considerations. George, let's work through some scenarios that might be presenting for some of our audience. So employee C is a receptionist at Company X. She was furloughed in March 2020 due to the COVID-19 pandemic. Now, Company X is reopening and has asked employee C to return to work. Employee C refuses, claiming she is afraid she will contract COVID if she comes back to work. Can she refuse to return to work? So the legal answer is no. The ADA does not grant an employee a general right to refuse to work. To refuse to work. Employee C's refusal would be a total refusal to complete the essential functions of her job. She cannot carry out her duties as a receptionist at home or remotely or by any other means other than being in the office. In any event, as we also just heard, a generalized fear of COVID-19 is just not protected. And so it's important to for employers to understand that these are, this may require an interactive process, but this particular scenario, wouldn't necessarily require that because the individual has expressed a generalized fear without pointing to a disability.
Exactly. And Amy, from a general HR perspective, one thing I will continue to reiterate is you want to find out why. Why is she afraid to come back into work? I mean, once you've got that answer, then in good faith, you can allow employee C to remain on furlough if you'd like for an additional month to ease his or her fears. But I would certainly recommend that you put an end date and document that and record that as well. So there's not this open-ended leave for this person. So again, make sure that you're asking the questions as to why, but again, put them back on furlough for additional month to ease their fears and recommend an end date to be documented.
That's a good point, George. I agree. And keep in mind also that some state or local laws might define a disability differently than the disability definitions we were reviewing a few minutes ago under the ADA. So for example, in California, a person has a disability if they have a mental or physical impairment that simply limits one or more major life activities, whereas under the ADA, that's a physical or mental impairment that substantially limits one or more major life activities. New York also recognizes several disabilities that federal law does not. So it is important to engage in that dialogue that you were just recommending.
Amy, if I could, this is Sean, if I could just jump in for 1 second. We had 2 questions come in that I think are kind of right on this topic. One is asking if an employee can complete their work responsibilities remotely, are employers protected to force employees back to the office, assuming there is no local government restrictions?
So I'll ask George to weigh in from the HR perspective, but from the legal perspective, is the employer protected? That's a tough question. Under most governmental restrictions, including the federal CDC guidelines and some OSHA guidelines that are more recent, there have been a lot of statements to the effect of employees should be encouraged to work remotely or telecommute where feasible for the business operations. Now, in the question that you've just posed, Sean, it sounds like it is feasible for the business operations for the individual to continue to work from home. However, the employer doesn't have a legal obligation to accommodate that unless the person presents with an actual covered disability that requires them to stay at home, for example, avoid a subway system in the case of like New York or Chicago, or has some other high risk category as defined by the CDC. outside of one of those protected characteristics, Sean, an employer can tell the employee that while their job can be performed from home, they should come back to the office because it sounds like they are either more comfortable at home, just not having to get dressed every day in the same way, or because they have a generalized fear of COVID, which is not protected.
Okay.
Exactly. And I would say, just to add to that from the HR perspective, one of the things that as an employer you need to make sure of is that if it's a particular department that you're not allowing some people to work from home and others to come back in the office. I would recommend a return to work program so that your employees know that this department is being required to come back on this particular date and everybody comes in. So you just want to make sure you're not allowing some to do it and some not, because that could put you in a whole lot of other hot water, other forms of discrimination, which we'll talk about here in the next few slides.
Great. Well, I don't want to hold things up. I just thought that question was pertinent to the exact slide. So we'll come back to some questions later.
Awesome.
Thanks, Sean.
So let's move to hypothetical number 2, if we could, please. So great. So employee D refuses to return to work and wants to continue working from home. He adds that he's developed a generalized anxiety disorder during his 3 months in quarantine. What should company Y do with this? Well, fear of COVID-19 in the workplace is not generally covered. However, what you have here is an individual who has identified a potential disability on top of that fear, and that is generalized anxiety disorder, which might be covered under the ADA or under certain state or local laws. So under that circumstance, which is different than the generalized fear without pointing to a disability, company Y is required to engage in the interactive process with this employee, provide an accommodation if it's reasonable, that doesn't constitute an undue hardship to the employer. Now, as part of that interactive process, what I would recommend is that company Y tell the employee all the workplace protocols that are in place to reduce the risk of COVID-19. We've got PPE, we're requiring masks, we're social distancing, we've staggered our shifts, we've limited customer access, we've got hand sanitizer on everybody's desks, we've got physical partitions or barriers up. If employee D still refuses to return, even after hearing those things, company Y should require a medical certification of the employee's alleged restrictions. If a leave of absence or a remote working arrangement is appropriate and wouldn't constitute an undue hardship to the company, the ADA might require, in this instance, company Y to provide that kind of an accommodation.
Yeah, I definitely agree with you 100%. And just to piggyback on that, I think it's so important that you communicate to your staff, to your employees, exactly what safety protocols you've got in place. That will help to reduce a lot of anxiety and fear. But to go into detail about the hypothetical 2, I also think that the company should attempt to put a time frame and limits on the accommodation, or at least set a future time for a reassessment of the accommodation through further interactive dialogue. In this way, the company can balance the employees' ADA rights, if any, with the business disruption of accommodations based on the COVID-19 issues. So here are some other types of accommodations that might arise in this COVID-19 world we live in. For example, Title VII comes to mind. Under Title VII, an employee might request a religious accommodation, such as perhaps being excused from a mandatory mask requirement. Here, the employer should discuss the request and provide the modification or alternative if feasible and not an undue hardship.
Correct, George. And interestingly, unlike requests for accommodations for disabilities under the ADA, religious accommodations under Title VII are considered under a completely different and lower standard. So employers don't need to provide a religious accommodation that results in more than a de minimis burden, either economic or non-economic. But an employer may not generally deny an accommodation based on a speculative burden. There needs to be some proof of a burden there. By the way, the caregiving responsibilities, and I'm sure you're seeing this in your practice every day, come to mind for me. These are folks who have caregiving responsibilities at home where they might be requesting a continued work from home arrangement, or to not be put back on the schedule at all and continue a leave of absence or continue a furlough, for example, as a result of having some caregiving responsibilities. Now, whether that's caring for an elderly person in the home or 3 children who all now have school closures and they all have to Zoom learn with a parent in the background somewhere. And that's really kind of the issue du jour for me, and I'm sure for you too, George, as we watch the school closure issue develop. So, one of the things to remember there from a legal standpoint is that employers have to make sure that they're not treating, for example, female caregivers better than male caregivers. So allowing mothers to work from home, but not allowing fathers, for example, or allowing parents to work from home remotely, but not allowing those who have an elderly person in their home to work remotely. So that's really something that comes to mind for me too. And the last thing I'll mention, George, is the Pregnancy Discrimination Act. That too is an issue du jour. It's important for employees to understand that pregnancy itself is not a disability in all jurisdictions, but pregnancy-related medical conditions might be under city, state, or federal law. Pregnant employees could also be entitled to some accommodation. You can't, on the other hand, however, prevent pregnant employees from coming in, which is something that the EEOC felt was necessary to remind employers of in a recent guidance document, saying that, I'm sorry, employers, we understand you may be well-intentioned, but you can't make assumptions about whether a pregnant employee should be provided a telework scenario. So, those are just some things that also come to mind for me.
Absolutely. Thanks, Amy. And the other thing too is age has also turned out to be an interesting one thing during this pandemic. The EEOC has explained that involuntarily excluding people from the workplace based on age being over 65 violates the ADEA. Even if the employer acted for benevolent reasons, such as protecting an employee due to a higher risk or severe illness from COVID-19. Unlike the ADA, the ADEA does not include a right to reasonable accommodation for older workers due to age. However, employers are free to provide flexibility to workers age 65 and older. The ADEA does not prohibit this, even if it results in younger workers ages 40 to 64 being treated less favorably based on age in comparison.
That's an excellent point, George. I think another issue we're seeing quite a bit of is employees saying, look, I feel like the CDC says that I am at higher risk because I'm over the age of 62, over the age of 65, whatever the current guidance might provide. So I'm going to continue to telework, or I'm not going to come in at all. Interestingly, there is no law, at least not on the federal level, that would require the employer to accommodate that. And I think employers might be getting tripped up on that, understanding age is normally a protected characteristic. But what you just said, George, I think is the takeaway on the accommodation piece.
Amy, I'm sorry, I just wanted to chime in for another moment because we had another question come about that I think is probably widely believed. That if people have a fear of using public transportation, or they're afraid of getting sick, or they have, that kind of anxiety, how does that, play into the different conversations that employers and employees would be having?
Well, I think it's the same issue, Sean. I mean, it goes back to, is this a generalized fear or is this a diagnosed condition? And that's really the key, because an employer has every right to request the medical documentation supporting whether somebody's fear is an actual disability. And so a generalized statement like, I'm scared to catch COVID-19 on the subway, well, that's going to be considered in that generalized fear of COVID category that is not protected. Contrast that with the individual who says, I have a fear of contracting COVID on the subway, and my doctor has diagnosed me with anxiety disorder during this pandemic, and here's a doctor's note saying I need to avoid the subway, so I can't come into the office because I have panic attacks as soon as I get on the subway. Even thinking about it, my heart starts palpitating. And so that's the dialogue, and that's that medical documentation request.
Right.
Absolutely.
And kind of a related solution that some people might believe in, what is the ability for an employer to mandate or an employee to request to have testing done?
Oh, yeah. So the EEOC says that an employer can mandate a COVID-19 test nowadays, just like an employer can mandate a flu vaccine. However, there are medical and religious aspects to that. There might have to be an exemption for a religious reason or an exemption for a medical reason. As it pertains to COVID-19, it is today considered, quote, a direct threat because of how widespread it can be in terms of the risk factor in the workplace. So you can mandate a test. However, the EEOC makes very clear that the employer has an obligation to ensure that the test is being conducted by a provided healthcare provider, a certified healthcare provider. It's a test that is has some accuracy behind it in terms of research. It's a widely known test. In other words, the employer can't send the employees to their neighbor who happened to purchase, a random set of 100 COVID-19 tests. Has to be something more sustained than that.
Great.
And let me piggyback on that as well. And this is the human resource, the human side of what we're speaking about here. If you've got an employee who has this anxiety or fear of getting on subways or public transportation, speak with your employee, have a real conversation with them. I mean, outside of it being for reasonable accommodation, you want to do the human side and talk to them. If you can provide an accommodation for them, or whether they have a disability, because you're looking at the human aspect of this, then do so. The flip side of that as well is when you get into some of the details around testing and managing medical information, if you don't have an HR professional on staff with you, make sure you reach out to legal counsel to make sure that you are tapping into all the aspects that you're going to be required to document and retain information, documentation for these other areas as well.
Yeah, and I would just say, George, that's an excellent point. There really are two sides to this, which is why George and I have linked up for this presentation. There's the question of, does the law require me to do A, B, C? And then there's the softer question of, should I do A, B, or C?
Exactly. All right, we can go to the next slide. So during the COVID-19, this health emergency, as an employer, you're faced with making multiple decisions, as we just spoke about some, such as updating safety rules, enhanced workplace precautions, and other issues related to layoffs, furloughs, recalling employees from furloughs, and rehiring employees from a layoff. It is imperative that employers consider the factors used in making the decision about who to fire, lay off, call back, and rehire. Failure to do so could result in allegations of discrimination. Allegations of an individual may use to file a claim of discrimination are stigmas, disparate treatment, disparate impact. So let's explore some of these potential reasons for filing a claim of discrimination. Let's go to the next slide. So as an employer, you have a legal obligation to provide a work environment free from discrimination and harassment during this COVID-19 health emergency. It is even more important to prevent and stop discrimination in the workplace. Unchecked discrimination can progress to harassment and lead to violations of civil rights. So let's talk about a stigma. Stigma is defined by a mark of disgrace associated with a particular circumstance, quality, or person. Fear and anxiety about the coronavirus is not an excuse to begin stigmatizing your employees and fellow coworkers. And just because the virus originated abroad, the virus is not linked to any particular race of people. So to be clear, stigma is discrimination and can be easily introduced into your workplace because of fear and lack of knowledge. Now, let me add to this as well. I work with about 80 different clients across the city of Houston, and one of the things that are occurring right now is this stigma thing where people who have tested positive, they've been cleared to come back to work, but people don't want to sit by them. So the employers are calling asking, well, can I move them over in this location here? So, and I have to warn them to be careful, because if not, you're creating basically a scarlet letter sort of effect. All people with COVID-19 are going to be on this side of the building and everyone else on this side. So again, you've got to be very careful on how you're actually handling these cases. What I would certainly recommend is if you've got employees who are feeling concerned about people coming back into the workplace, reiterate what the protocols are, reiterate that you're following CDC guidance, and make sure they're aware that you're on top of everything that needs to be done to protect them in their health and safety. If you do that, more than likely, you're going to begin to minimize the ability for them to create stigmas and also create these other things around, different minority groups or certain racial group, ethnic groups as well. So just keep that in mind. You want to be clear not to introduce stigmas into your workplace.
So let's talk about disparate treatment and disparate impact. Disparate treatment occurs when somebody in a protected category is intentionally or purposefully treated differently than people who are not within their protected category. Disparate impact is different. Disparate impact occurs when a neutral practice or policy or rule that seems to be fair and neutral results in a disproportionate impact on a protected group. In other words, the policy or practice that you use unintentionally affects a protected group. So the classic example is testing all applicants and using results from that test, and unintentionally eliminate certain minority applicants disproportionately. That would be a disparate impact. Disparate impact lawsuits generally involve multiple employees. So the damages claims can be very high. The lawsuits can be very costly. The cases are also attractive to attorneys who specialize in handling class actions or on a contingent fee basis. So as employers look to reopen their doors in this COVID-19 era, they need to be aware of a number of regulations that we'll now begin to talk about around rebuilding your workforce. Now, we all know federal law prohibits discrimination based on a number of protected categories, and state and city adds to that. So you have race and color, sex, national origin, age, disability, and those laws prohibit both disparate treatment and disparate impact. And obviously, there are many state and city laws that also expand. For example, there are some laws that protect marital status. There are some laws on the city level that protect domestic violence status, caregiver responsibility status, for example.
Exactly. So look, as you begin to make decisions on who to lay off versus who to furlough or who to bring back, please look at the broader picture to ensure that there's not any sort of disparate action occurring. This can be avoided by establishing selection criteria and the decisional units to determine who should or should not be a part of a particular cause of action that will affect your employees.
Yeah, so on that point, George, rebuilding your workforce, the question many employers have right now is how? In other words, who to hire? Am I recalling furloughed employees? Am I rehiring laid off employees? Am I hiring new applicants? So typically hiring claims are based on age, gender, and race for the most part. All of those more traditional discrimination claims, of course, remain a possibility. But given the unique circumstances presented by COVID, employers might begin to see more unique disparate impact claims filed by groups of individuals who may be or may be perceived to be medically vulnerable, those with childcare or other familial responsibilities. Well, I'm not going to recall her because I heard her kid's school is not opening, so she's not going to be able to do the job from her home, or she'll be able to come in. And people who indicate a preference for working remotely, well, then I'm not going to call them back. Other similar categories that are really unique to this era that we're living in. So it's really important, to the point you made earlier, George, to conduct a careful analysis to ensure that there are no trends forming that could support one of these disparate impact claims. Even the decision of which labor supply source to choose from in rebuilding your workforce, like I said, current employees, former employees, external applicants, could land an employer in hot water. So here's an example. If an employer were to decide to hire entirely anew from an external applicant pool because they laid off a bunch of other people before, maybe furloughed some people, and they choose all younger people to fill the jobs that were previously filled by older workers who were laid off due to the pandemic, the older workers might claim that their prior employer's seemingly neutral practice of hiring anew, as compared to rehiring the previously laid off workers, an option that frankly might never have occurred to the employer in the first place, disparately impacted older people. Now, they might also argue that the company intended to use an external applicant flow because it knew that this would yield a younger workforce. On a related note, employers cannot exclude employees from coming to work solely because of their age, like we were talking about before. Another thing to know about or keep your eyes on is the substantial changes in the labor pool that is available now since COVID. I mean, the supply of available workers now includes former employees, includes recently unemployed applicants, includes more recent graduates, frankly. After deciding the labor force, because of the evolving sort of medical and legal risks associated with COVID, employers have been given leeway to adopt certain infection control measures, like screening employees before they enter the workplace, which was Sean's question earlier.
Absolutely. So while you're considering all these things, let's look at some of the factors and considerations in bringing employees back. Some factors to consider are going to be priority for furloughed, or former employees or volunteers. Previously communicated recall criteria. These are factors you want to take into consideration. Applicants who prefer or need to work remotely. The age or other protected characteristics. These are some factors. Now, considerations as well are going to be job classifications, same pay levels, new working conditions. I stress to take these in consideration and really look at these from a broader standpoint, because often what's happening is we are rushing so quickly to regain and refill our operations that we are missing the mark and not putting these things first and foremost. So please, I would just ask you all to take that time to consider the job classifications, what the pay levels are, who you're actually bringing back. As Amy mentioned before, you don't want to put yourself in a position where you're creating that desperate sort of situation.
Yeah, I think, George, that my legal takeaway on this particular topic, rebuilding your workforce, is probably that employers can expect to be challenged on the decisions that they are making in rebuilding the workforce. I mean, who is being recalled from furlough first, and why? Is anyone being recalled from furlough, or are we going to hire anew for roles? If we're not hiring anew and we want to go to rehiring laid off employees, calling them up and saying, hey, Susie, I know we laid you off in March. Business is back. We actually need you back. Why the choice of Susie versus Jennifer, who's pregnant, or Chris, who's 65, right? And so employers need to be wary of the fact that each move that they make in rebuilding their workforces and reopening their doors is likely to be challenged, whether that's an attorney demand letter, an internal complaint, a full-blown lawsuit, any EOC charge, we don't know. So that being the case, it would be really important for employers to first understand the demographics of their workforce before the onset of the pandemic. So go back in time before March 13th and look, what did my workforce look like at that time? Then you'd want to compare that to the workforce during the pandemic. Okay, how are things looking now? And then where you're heading after the pandemic as you're reopening your doors. So now is really the opportunity for employers to sit down and ensure that their employee data is complete, make sure it's accurate, starting at least as far back as January 2020. It's also really important that employers document and maintain data about their decisions in rebuilding the workforce. So who is eligible for selection to come back? Is it essential jobs that I'm looking at? Was it performance measures that I used? What's the outcome of the selection? Am I going furlough, termination, pay cuts, hiring, rehiring? What did I do at each phase of the pandemic? Where are my affected people? Certain locations, offices, stores, headquarters. When were the decisions communicated and then put into effect? Why were some people selected and others not? What were the metrics I used? Essential job functions, performance ratings, first in, first out, seniority, and how were the decisions made? Who made those decisions, and how did they participate in those decisions?
Exactly. And the reason that's important is because you want to be able to defend your position if you're called on the carpet for any of these areas. So it's important to get counsel, legal counsel, HR, and your leadership involved early on and keep them involved during this process. Also, employers should proactively analyze the data in real time to minimize disparate impact and maintain data on applicants, screens, interviews, and other evaluations, offers, hires, All of these things, documenting the decision-making process, who, what, when, where, and why, can also help minimize legal risk, ensure compliance with the law, and again, allow you to defend your position if you ever called to the carpet on something.
So we're rounding the bend here, if you can believe that, George, on the end of our presentation. So I thought we would end with a hypothetical. So suppose company A furloughed 20 call center operators in March 2020 due to a COVID-19 closure. Company A is now considering reopening its business and needs only 10 operators to fill those positions. What are the legal and HR considerations in making these decisions? Well, let's break it down. We've talked about the HR and the legal considerations. Let's work through it now. So what are some of the considerations in either recalling or rehiring laid off employees? Well, it could very well be the case that not all employees who were furloughed at the beginning of the pandemic continue to be needed. So in this current hypothetical, company A has determined that it can only sustain the return of 10 call center operators, but it's got 20 on furlough. How to decide which 10 to pull back and which 10 to remain on furlough or potentially be terminated? Well, first, if an employer expressly told employees about how recall selection decisions were going to be made later, the employer has to make every effort to follow the announced criteria they previously set forth. If an employer's particular business allows, the employer can also consider asking for volunteers to return to work. The employer might be very surprised at how few volunteers there might be. We don't know, right? It might also be the case that company A previously took the more permanent step of laying off as compared to furloughing these 20 call center operators, now finds itself in the position of needing 10. Well, same analysis. Which will be contacted and offered the opportunity to be rehired? Which won't? Why? What selection criteria, hopefully objective factors, are being utilized? Is it years of service, seniority, particular skill sets, salary grade or amount? Or is it going to be based on subjective factors? I liked this person better than that person. This person always had an attitude, that person didn't. If employers use performance measures, by the way, in making these decisions, the question of whether performance evaluations prior to the lockdown were fair, job-related, and consistently and accurately handled becomes incredibly relevant. So these issues obviously suggest that considerations along these lines should include complying with anti-discrimination laws. For example, we're not going to discriminate against people who are older, who are disabled, who we regard as disabled. To your point earlier, a consideration should not be, well, I'm not recalling him because I heard he had COVID last month. So we've got to be careful about that one too. And so then lastly, just George, what about hiring anew, right? Completely, should that be avoided altogether? Does an employer have an obligation to recall or rehire employees? Well, not necessarily. I mean, the baseline and the perhaps most obvious point here is that when evaluating whether to hire new employees, employers have to consider all qualified candidates fairly and without regard to any protected characteristics. I mean, that's really the takeaway point there, as they would with any business decision. So, it's really important for employers to compare the demographics of external candidates to the characteristics of the pool of qualified, interested, and similarly situated individuals who might be on furlough or layoff.
Amy, if I could just jump in, because we're approaching the 3 o'clock hour pretty quickly. There was a couple more questions that we've gotten. I thought I'd throw them out there to you guys and hear your reaction. One participant is asking, they have a number of employees that are required to be in the office working on site in manufacturing. What are your thoughts on employees that are asking not to wear a mask for religious reasons?
Yeah. We touched upon that very generally earlier, and it's a good circle back. So it is the case that Title VII and many state and city laws would require an employer to accommodate a religious belief that prohibits a person from wearing a face mask. However, the accommodation still has to be reasonable and cannot cause an undue burden or direct threat. to the others in the workforce. Remember, the CDC has made very clear, as has OSHA, that masks are not for the protection of the wearer of the mask. Masks are for the protection of the people around the wearer. So what the employer needs to do is engage in the interactive process and determine, can I get this person back on my manufacturing floor or in my plant without wearing a mask and without causing any threat to my other employees? Maybe it's those plastic barriers George was describing earlier for the person's workstation. Maybe the person uses a different entrance and exit to come in and out. Maybe the person is situated 20 feet away from the other workers in their own workspace. Maybe there's staggered shifts. That person comes in from X to Y time, other employees are A to B's time. So that's really the kind of considerations that come into play there.
Great. No, I think that's a great response. And then another question, and I think we might have touched on this earlier, but somebody is asking, are there any circumstances where it's acceptable for the employer to initiate an accommodation to an employee with a disability or in a high-risk category, even if the employee had not asked for it? George,
do you want to take that one? Sounds right up your alley.
Well, here's the thing. I think and we did touch base on this before. The thing to consider here is you don't want to set that person up and treat them as a disability if, in fact, they're not asking or presenting one to you. I think it's all well intended that you want to take care of that person. But again, I would not impose any sort of accommodations on the employee if, one, they're not asking for it, or two, it's not required for them. So the answer I would say is no. I would not push an accommodation on someone who's not asking for it.
Right. All right, great. Well, I know that we're getting close to our 3 o'clock hour. I thought I'd just let you guys continue on, and we'll start to wrap things up.
Certainly. Let's just get through with the hypothetical that we're in right now. And here's some considerations on this hypothetical number 3 from HR standpoint. There are numerous amounts of considerations from HR. In detail, here's an overview of some of the more important topics that you should consider based on this hypothetical we just went through. Proper communication, executing a clear plan of how the organization will reopen new and existing processes. Make sure that's clear, clean through your communication processes. New and existing policies, determining what policies need to be amended, suspended, and or developed, or the development of new policies as well, such as remote work, travel policies, hygiene and safety policies. I would implore upon everyone who's listening to this to really take a step back and look at your policies and determine which ones are going to be adequate, which ones, again, need to be further developed or even need to be changed. The last thing to consider are going to be recall procedures, such as Amy went through, determining your selection criteria. Please just don't take and start randomly picking people. You're going to set yourself up for some high risk here. So determining selection criteria, notifying unemployment, analyzing and reviewing the return and non-return of employees to prevent the appearance, again, of any sort of disparate impact occurring. These are some things I would ask for you guys to consider from an HR standpoint. Amy?
Yeah, so why don't we just go ahead and wrap up on the next slide. We're at the top of the hour, George. Why don't you take us through some do's and don'ts and some takeaways from the day?
Absolutely. So again, this has been a great opportunity. HR and legal, we partner all the time together. We don't get opportunity to get on calls like this together. So I really appreciate the time with Amy. But here's some things that we've put together as a takeaway for you all as a do and don't. Certainly do engage in the interactive process, as we just mentioned. Enforce company policies that are designed to prevent workplace discrimination. Establish business reasons or selection criteria to determine who to lay off, who to furlough, and who to return to work or rehire. Seek advice of legal counsel in the matters of hiring and firing due to COVID-19 related issues. Lastly, let's do not immediately have an employee that cannot accommodate and engage in the interactive process and consider, I'm sorry, my screen just went blank on me, considering their request. Do not make statements or engage in an activity related to COVID-19 that would single out an individual or a group of people. Do not use furlough and layoffs as a means for getting rid of your problem employees without a bona fide business reason. And lastly, do not deny employment, promotion, or bonus without the advice of an employment attorney based on COVID-19 issues. With that said, I want to thank everybody for participating in this webinar. And Sean, I'll let you take it from there.
Yeah, so I guess to wrap things up, we've provided some resources here that people can refer to, try and find out some more information. We should have a slide coming up as well that's going to have some contact information for Amy and myself. And I guess the last thought I would leave for people as we've gone through this webinar and we've learned such valuable information, I would also add that people should really explore, if they don't have a relationship with a trusted legal advisor, they should explore that. And if they don't have an HR system in place that allows them to document all the interactions with employees, something that Insperity has a very robust system for, they should be exploring the use of those systems, whether it's Insperity or somebody else. But they really want to try and have a system in place that allows them to document interactions and employee performance reviews and so on to try and prepare themselves moving forward. So with that, we'll end for the day. I hope everybody enjoys the rest of the afternoon. I hope everybody found this to be an informative webinar and a productive use of time. And that would be it for today. So I look forward to hearing from people and hopefully speaking to everybody soon. Thanks a lot.
Thank you.
Thanks, everyone.